justice, qualities that I think will and should translate immediately to a judgeship. We've handled many cases, Jim and I, together since we went to separate offices. I continue to watch him and admire him and respect him as a lawyer. I've always found him to be diligent, committed to the law, empathetic, well prepared. He's also, and I think these words are important, he's humble and he's very wise. His instincts are sound and his judgments are very good. Our courts will be a better place if he becomes a judge. Jim has tried, I know, approximately 20 murder cases and has handled a wealth of civil employment and other criminal cases as well. He has a wealth of academic and practical experience. This isn't letting go of a big secret, but whenever I practice or appear before a judge I do not know, I poll my colleagues, what is she like? What is he like? Most of the time, because of the work of people like you, the reports are very good. Occasionally, not so good, but most of the time, the reports are very good. We have good judges here. And I'm confident that if Jim Boudreau becomes a judge of the Superior Court, lawyers in the future will be told, as they say, what's Judge Boudreau like? They will be told, regardless of the kind of case you have, he is a great judge and the perfect judge for you. He will listen with an open mind. He's not biased. He's not prejudiced. He's polite. He's fair. And he will always, always do exactly what he thinks is the right thing to do. I recommend him without hesitation and in the strongest words that I can summons for you this morning. Thank you.
Thank you.
Thank you.
Can I?
Yes, Mr. Pollabom. Ian
Chris?
Pollabom.
You have.
Councilor Dooling.
I'm sorry.
Not a question, just good to see you.
Nice to see you.
Glad
too.
you're here. I'm gonna tell Barry I saw you.
Okay, please do.
And
I haven't seen him in a decade.
don't retire.
I'm not
Keep
planning on
practicing.
it anytime soon. No, thank you. Thank you.
I just want to ask you a question.
Oh, I'm sorry.
That's okay. I wanted to ask you, you've known him for 35 years. And
Oh, right.
so you have seen him in court
Many
as a
times.
district attorney. All right, and there's so many cases you could talk about, but is one that's outstanding to you that really he impressed you so much?
Well, I don't think I could point to one case because he always impresses me. Jim is always well prepared. He's honest. He's honorable. Judges like him. Juries like him. He's a very decent man, and that always comes through. And there have been so many cases where we've worked side by side with one another. A first-degree murder case, we've worked side by side on that. But district courts, superior courts, he's always been one of those people I'm honored to work with.
Well, thank you for what you do. Your testimony means a lot.
Thank you very much. Thank you.
Yes, Mr. Ian Pollabom.
Okay. Good morning, everybody. Ian Pollabom, Chief of the Domestic Violence and Sexual Assault Unit in the Suffolk DA's office. I've been a prosecutor in Massachusetts for a scary amount of time, about 26 years. The idea that my speaking might help somebody get on the Superior Court bench is both an honor in a general sense and an honor specifically that Attorney Jim Boudreau is the one who asked me to speak for him. I spent about 10 years in homicide, and during that time got to know Mr. Boudreau. We didn't have many cases together, but there were two in particular that stand out. One ended up being a resolution of a particularly awful homicide case, and one was a murder trial that lasted about 3 weeks. During that time, I mean, I saw what people are looking for in terms of, judicial qualities, command of the law, command of the facts of a case, which is important when you're dealing with a case. Very thorough research, very good writing, very clear reasoning. Also respect for the law, even as a zealous advocate. As somebody on the other side, it's easier for me when I can argue, don't listen to his argument, it's totally wrong, it disregards the case law. I could never say that with Mr. Boudreau because he had a command of the case law. And if it was an uphill argument for his client, he would acknowledge that and find a way around it to adapt, his situation, make some argument that was reasonable and credible about why his client's situation was a little different. So I saw credibility. I saw respect for people, everybody. I saw transparency and honesty. If Mr. Boudreau, as an advocate for his client, told one of us something about his client or about evidence he expected to present or about his view of something in our evidence that maybe we should take a closer look at, we could take that to the bank. We could take that seriously. And he was always, straight shooter is a cliche, I guess, but that's what he always has been. So that's Attorney Boudreau. During that 3-week murder trial, I also saw some of Mr. Boudreau or Jim Boudreau. For the first 2 or 3 days of that, we were doing jury selection, what people like to call the dinner table method, where the judge is at the head of the table, the parties sit along the sides of the table, and the jurors come in one by one and sit at the foot of the table for individual questioning. And I just happened to be sitting a few feet across the table from Mr. Boudreau and his client for those 3 days, even closer than we normally were in the courtroom. And two things struck me about him at that point that stuck with me long before I ever thought I'd be speaking on his behalf. One was his interactions with the client, who was a young man who we had charged with a pretty awful and callous gang murder. And this was somebody who, when he came into the courtroom from the lockup, I could tell that he was glad to see his lawyer every day. They would sit down and they would have a conversation. And when you're in the courtroom and attorney and client are talking, you try to be polite and pull away and not eavesdrop. But I could hear the tone of voice and I could see the conversation, and I stressed that it was a conversation where the client was at ease talking to him. I mean, Mr. Lawson said judges like him, jurors like him. I think it's accurate to say clients like him and trust him. He didn't, he speaks with people. He doesn't speak to them, just to them or at them, let alone speaking down to them. His approach really puts people at ease, makes people feel more trusting. And that's both giving him credibility when he's on the other side, and I can only infer trusting him when he's their advocate. When people on the JNC or on the joint bar call around and talk to lawyers, one of the questions they sometimes ask is, bottom line, if you walked into a courtroom and you saw so-and-so on the bench, what would your reaction be? What would you think? I can say without hesitation that if I walked into a superior courtroom and I saw Attorney Boudreau, Mr. Boudreau, Jim Boudreau on the bench, I would say that's great. I would say that the court is in good hands. I would say that he is somebody, and I think other people should and will think that he's somebody who's going to listen. He's somebody who's very smart, but never talks about how smart he is. He's thoughtful. He's respectful. He's interested in people, not just issues. Going back to the dinner table jury selection, the other thing I noticed is when these individual jurors came in, of course, he asked the right strategic questions, what's this juror's views on crime and gangs and other issues in the case. But he also, just the way he carried himself and asked even those few questions, he was clearly interested in the people and appreciative that they were there. And I think that if you confirm him for the bench, he'll carry that same interest in people, not just issues and cases. And the legal community and the larger world will be better for it. Thank you.
Thank you.
Any questions, Councilor Glenny?
Thank you for your testimony. I've said it before, I've been here a long time, and we have people that sit in that seat. And I've asked, how do you know this nominee? I saw him once in court, but I mean, what you said is from your heart and your head, and I really appreciate that. Now, I know writing is so important on the Superior Court. And this council, not me, but this council voted for someone for the district court and then came back and voted for the Superior Court. And guess what? I found out that he thought there was too much writing in the Superior Court, so he got back to the district court. So I'm going to ask you about his writing. You're the first witness in all my years that has ever mentioned his writing, the nominee's writing. So tell me about that.
Well, first of all, it's good writing. It's the kind where if a judge reads it, you say, this reads, it's got the right legal terms, but it's English, it's understandable, it's organized. But I also, one of the things we like to do, again, as a prosecutor, when we get a defense motion, we'll check it. Does that case really say what the defense attorney says it says? Because sometimes people will give us room to say, Judge, that's not what that case says. He's misinterpreting it. That never happened with Mr. Boudreau. Like I said, if there was adverse case law that he had to somehow try to get the court to go around, he would acknowledge that head on. And that's why I say, I think if he's in a position of being a judge to synthesize what the case law is, he's already most of the way there in terms of framing an issue and seeing what's out there, seeing what authority is there. I think the writing too supports his credibility because it's solidly supported. He stated the facts of the case accurately. He stated the law that was out there accurately. Made it more challenging. I think it made me a better lawyer to have to respond to these things. And I hope that helps.
Oh, thank you very much. Your testimony means a lot. Thank you.
Thank you. Thank you very much. Counselor, quick question. Who was that judge you were referring to about?
Pardon me?
Who was that judge who was district court?
Wasn't it Curran?
Well, I can
I
just,
believe it was. But the interesting.
excuse me. I can just tell you about Dennis Curran. He is a brilliant, or he was a brilliant jurist. Graduated from Boston Latin School, top of his class, one of the finest schools in the country. He then went to the University of Pennsylvania, Ivy League school, again, one of the top schools in the country. And then after that, he went to, again, one of the finest law schools in the country, I believe, the University of Virginia Law School. He's a brilliant individual. And when it comes to writing, he was about as smart as they can come. Did you want to say something, Counselor?
I just have to add to that. I appeared in front of him hundreds of times. He was a phenomenal judge. Phenomenal judge.
I guess this is
I don't
about
think I,
isn't it?
Excuse me.
I don't think I ever met anybody with more compassion. And he was a brilliant judge.
Thank you very much. Thank you very much.
Thank you.
Thank you, sir. You want to introduce, I think, your final witness?
The Honorable Michael Dooling.
Judge Dooling was almost there.
Almost. When you said brilliant, it stopped at that. Yeah. I'm working on it. I'm working on it. Good morning, everyone. I'm Michael Dooling. It was my pleasure to be in front of you 2 years ago, and it's my pleasure to be in front of you again today. I'm very honored to be here and to talk about my friend Jim Boudreau. So Jim's, I met him about 20 years ago. I haven't known him as long as Mr. Lawson has, but I've known him for about 20 years. And his reputation preceded him. His reputation in the legal community was that of a very brilliant trial attorney. But as I got to know him better over the last 20 years, I've come to find out that there's a lot more to him than that. I've co-counseled cases with him in the federal court and also some very serious cases in the state court. And one of the ones that stands out in kind of in response to what you had asked earlier, Counselor, was the case that we had over in Middlesex County. It was a homicide. It was 3 juveniles. And it was a case that we resolved short of trial. And I certainly give a lot of credit to the Middlesex DA's office for their efforts in that. But I give a lot of the credit in that case to Jim, his empathy for our clients, not just his own, but mine as well. And then a third young man was tremendous, but also his knowledge of the law. And I learned a lot from him on that case, a lot about the development of the juvenile brain and the things that have become so much in the forefront over the last 20 years in the criminal system. And not only is Jim a fine criminal attorney, he's also a very good civil lawyer as well. I've had the opportunity to refer him cases over the years of a civil nature, cases that might have had both a civil component and a criminal component as well. He's also a very good writer. He's done a lot of appeals. As Ian Pallenbaum said, I think his writing is straight and to the point, and he speaks the law by way of the English language, so to speak. His temperament is tremendous. What you're going to see here is what I think you'll see on the bench. A guy who's very modest, he's unflappable, and he handles himself very well in stressful situations. His knowledge of the law is tremendous, both in the state and in the federal as well. His fairness, his empathy, and some of the things that really jump out at me are his qualities as a human being. When I parked my car this morning over at Suffolk, the court officer said, "What are you doing here? You're sitting over in Middlesex. Why are you parking your car here?" And I said, "I'm going to go testify for Jim Bedreau." And the 2 court officers I spoke to both said he's going to be a fabulous judge. He was a great trial lawyer. He's a great guy. And I think that speaks volumes. That speaks very, very loudly to me that he's going to be a very good and fair judge. He's a regular person. He's been self-employed for years. He's had to pay the light bill. He's had to worry about where his next client was coming from. He's done a lot of things pro bono. I think if you look at his application, you'll see that he was someone that has done a tremendous amount of pro bono work, both in a clinical nature when he was over in the Harvard Clinic, but also on an individual and personal basis with people who came into him who might not have had a great deal of money. And he represented them and he gave a zealous representation. So I think he's going to be a tremendous addition to the Superior Court, and I'm very proud to be his friend, and I'm very proud to be his colleague, and I'm very proud to come up here and testify about him.
Thank you very much. Any questions from the judge?
Nice to see you. Thank you.
Thank you.
Counselor Devaney?
Good to see you again.
Nice to see you as well.
2 years.
2 years.
2 years.
Yeah.
You've had a tough year this past year.
Last year has been a tough year. I think the court system, as I'm sure the council has, is I've had a chance to watch a couple of the hearings. Everybody has performed very well. And it's, I think professionally that the court system has come through it in a tremendous way. We've got great new leadership with Chief back here, and I'm looking forward to the things that we can do post-COVID.
Right.
But it's been a tough year personally for a lot of
No,
people.
it has. Are you back to normal, people coming in?
When I was in Suffolk, I was sitting in the first session, criminal. And I would say we were at about 30 to 40% on a given day. A lot of people still participating by Zoom, and a lot of people had started to come back in. In civil, I still think that other than the jury trials that we're trying to do, that you're seeing a majority of it over Zoom.
So during that time, have you seen the nominee during all this pandemic?
I have not, he hasn't been in front of me as a judge,
Yeah.
but I've talked to him on the phone a lot, and I encouraged him to apply a couple of years ago when he put his application in. And I know, I got a chance to meet his wonderful family today, his son, who's so proud to be here in the State House.
He's so proud of them too.
Yeah,
Well, the thing is that, I didn't vote for all of them that I sent, but I sent a lot of good people over there.
absolutely.
But 4 years ago, we sent someone over there with 6 cases in 21 years in Superior Court. Shame, okay? So he couldn't count his. He couldn't count his.
He has had, I have watched him try at least 3 or 4 murders in Suffolk Superior Court. And I think I watched him try one over in, when we were over in the federal court as well, when Suffolk was over there. And I've had a chance to see him try cases in the federal court. He's done a tremendous amount of work in the state court. I mean, I'm very proud of the Superior Court, as I think everybody knows. I essentially have always viewed myself as having grown up in Suffolk Superior Court since I was 25 or 26 years old. And I love the Superior Court. I think he does too.
Well, it's my pride vote for you.
Thank you.
And what a tribute to the nominee to have you come and be a
Thank you.
witness. Thank you.
Thank you so much.
Thank you.
One quick question. Maybe I should ask the chief, but I'll ask you.
Yeah,
I know the governor has proposed going forward
right.
in the future, a hybrid system. People have childcare issues. Put COVID aside.
Yeah,
He recommends, I know, for instance, at the Department of Industrial Accidents, it's the workers' comp.
yeah,
You don't have to show up. You
right.
can, there is a designated day, and I believe it's Tuesday. And for what, you don't have to have you can just say, I got childcare issues, or, I'm not feeling that great, or I don't want to travel to Springfield. I would like to do it next week on Tuesday, to do it by Zoom or webcam, WebEx. What's the procedure at the Superior Court? Like motions? Well, give me your sense.
Yeah, my sense of what we've been doing in the Superior Court is this. We realize that the fact that COVID has given us a tremendous amount of issues. And the first thing that we want to take into account is public health, right along with justice. And justice on a lot of criminal cases requires that the defendant be there. The defendant should be there to hear his motion. The defendant should be there at his arraignment. The defendant obviously should participate in a plea. And obviously, we're starting to gear up for trials. I think that where Zoom, I've found it, this is.
Just so I can, no, I don't mean to interrupt you.
Yeah,
My sense is the governor is suggesting 2, 3, 5, 10 years down the road too.
yeah,
He's not talking just post-COVID until everything gets settled.
right,
He's looking at the future.
yeah.
And I just want to know from the, and again, not to interrupt you, I apologize.
Yeah, no,
Like
that's
the
okay.
DIA, you don't have to show up.
Yeah,
You know what? I got my kids, I got a 2-year-old and a 3, I don't, not me,
Yeah.
I'm a man. 2, 3, I got to take care
Yeah.
of my kids. That's what I'm trying to get a sense. What's the policy? Is there one yet?
I think it's evolving, and I think that, that the policy is that we're still gonna do some Zoom hearings going forward. I think that there's a place for it. I think that the place is more the civil status conference, that as a civil practitioner for years, Counselor Ryanella, you've gone to a million status conferences at 2:00, where you're sitting there in a room of people and they say, Mr. Ryanella, Mr. Representative of the insurance company, is this case ready for trial? You say, yes. Okay, pick a trial date. Those type of conferences, I think, are the ones that are ripe for Zoom. Actually going in and doing a summary judgment motion or a Rule 12b-6, maybe you want to have the attorneys there. And I think that as we evolve over the next year or two, the next 5 years or 10 years, that there's going to be some components of it. And I think, though, I mean, as you and I and many of the other people here have grown up in this system, that it's good to see people. I find the advocacy is better as a judge if I see somebody standing in front of me, as opposed to some image that's on Zoom that I'm straining across the desk to see. And I also think that as a court, that our primary goal is to achieve justice and show respect to those people, the lawyers and the clients that come in front of us. And I think that in-person hearings are probably the best way to do that. with a Zoom component for some stuff like status hearing.
Yeah, no, I personally agree with you.
Yeah.
You know, as a personal injury, attorney who does plaintiff's work, it's good to see who's on the other side. You develop friendships, you have some
Yeah.
camaraderie, and the bottom line is, the goal is to resolve the case.
Right.
And if you have some connection with the other side, it may help in resolving the case. So I like the in-person myself, but
There's a lot of cases that get resolved on some of those dates when the attorneys are walking down the courthouse
Sure.
and maybe not a formal offer, but you say, hey, if you offer this, my client might take it. And then the next thing you know, a week later, you get a resolved case and the client's happy.
I appreciate it. Thank you very much.
Thank you also very much.
Sure.
Thank you.
All right.
At this point, Mr. Boudreau, if you'd like to, that will exhaust the people who are in support of your nomination. Is there anyone here in opposition to the nomination of Mr. Boudreau? There being no one in opposition, before we hear your presentation, I know you have family, friends, colleagues to be. If you'd like to introduce them, this would be the appropriate time.
We've already met my witnesses, and Chief Rigor, who was here. My wife, Donna Griffith, seated over there with my son, Ethan Boudreau, and Ethan is a huge basketball player. He's always been compared to Steph Curry in his own mind. And,
Wow. What's the status of the championship between Phoenix and Milwaukee? That's over, isn't it? Milwaukee won. All right, that's good.
he had to read about it in the paper this morning, but it was a little late last night.
He's on it.
Good to see you folks. I haven't met you before, but you're my neighbor. I live on Pond Street. Oh, but JP, I've lived there my whole life. I love JP. I went to the Manning School, right? That's where we all vote. Look, good to see you. Nice to meet you. At this point, Mr. Boudreau, if you'd like to make a brief presentation as to why you think you'd be a good addition to the Superior Court.
Thank you, Council Iannello. I appreciate it. I introduced my family. Councilors, I want to thank each and every one of you for coming today, and for most, if not all of you, having spoken to me in advance, or at least to some of my colleagues. I really appreciate that. I understand your schedules are busy, and your personal lives are equally demanding of you. I want to thank, of course, Governor Baker and Lieutenant Governor Polito for my nomination to the court, and I'm humbled by their confidence in my candidacy. Ultimately, we are a sum of our parts. With me, that includes community service, my legal experience, and above all, family. So I'd like to start by thanking my family, my mother, Sue, who is 89 and has raised 3 children to be independent and self-sufficient. My brother Ken and his family, who have always been supportive and caring. My late father, Bill, who taught me that compassion and empathy weren't just ideas, but were core values. And my sister Amy, who we lost to cancer just before COVID came. She epitomized grace and dignity in the face of personal tragedy, and we all learned from that. And of course, my 2 boys, Ethan, who you've already met, and my son, Dylan, who I adore, who could not be here today. It's no secret that our children need us in their lives, and I try to spend as much time with my kids as I can. And, the pros and cons of the pandemic were we get to spend time with our loved ones, and obviously the impact was horrible otherwise. And finally, I want to thank my wife, Donna, who has always been an inspiration for me, from the trials and tribulations of growing up in Little Rock, Arkansas in the 1970s to her frontline work as an anesthesiologist throughout the pandemic. She's a model of poise, strength, and selflessness to both our family and to our friends. And we are the sum of our parts and experiences, and so am I. And let me briefly share some of my background so you understand why I chose this path. Now, I don't want to bore you with my history, but I grew up in Winthrop, which is right next to the airport, as we all know. And when I was a kid, we had Deer Island Prison, the House of Corrections, and which was later replaced by the sewage plant of the same name. We were always protesting, circulating petitions about noise and water and bacteria counts and et cetera. So it was a very political town, and I was always involved in community politics. In the early 1980s, I went to UMass Amherst and received my degree. I paid my own way through college and did the same through Northeastern University Law School, as my family had moderate means. And while at Northeastern, I worked at co-opt for a large firm at one point, the Civil Rights Division of the Attorney General's office, and then for a judge. And all these experiences have helped my views both as a lawyer and as a person. Immediately after law school, I clerked for the Superior Court, and the very court that I'm obviously nominated for a judgeship. And I quickly found a mentor in the name of Judge Harold Flannery. I don't know if any of you knew Judge Flannery, but I worked with him for almost a year. And before becoming a judge, he served as an assistant U.S. attorney. He was part of a team who went into the Deep South to enforce the Voter Rights Act, which was obviously a big issue at that time, as it is today. Given our shared interest in the civil rights, we bonded and stayed in touch for many years. While Judge Flannery was a man of principle, he was above all else fair and compassionate. Throughout his time on the bench, he personified judicial grace, integrity, and dignity. He set a thoughtful and welcoming tone in the courtroom where everybody felt heard and included. Although Judge Flannery eventually rose to the appeals court, it was one decision that he made in the Superior Court that exemplified his goal of equal justice and equality in the law. In that decision, he found that gay pride members could not be excluded by organizers of the South Boston Parade. And while the SJC affirmed that decision, many disagreed with it, including the U.S. Supreme Court, which overruled it. Some viewed his decision as courageous, given the context and the time. But Judge Flannery always waved that off. And he said, don't ever confuse courage with doing the right thing. And I think his response was both wise and instructive to all judges. They should always try to do what's right and equitable, regardless of whether it's popular. And while I'm not perfect, I aspire to be that sort of judge. I'll talk a little bit about my experience as a lawyer. You've heard some from my witnesses, and I appreciated their time in coming here. Thank you. I've tried close to, as you heard, 20 homicide cases over my career. I've regularly represented indigent clients because I believe that those who are less fortunate are entitled to the same equality or quality representation of those with means. Over the last 30 years, I've represented hundreds of defendants in courts throughout the Commonwealth. I've tried cases where I needed to manage hundreds of thousands of documents, and some of those cases went on for 3 months. Most were complex, and most required significant preparation and writing. And while I was always been a zealous advocate for my clients, I'm confident that every prosecutor that has dealt with me would say that I'm prepared, fair, and ethical. I also had a robust civil practice after my clerkship. I worked for a civil litigation firm, and after joining O'Terry, Weinberg, and Lawson with Mr. Lawson, I started handling their civil work, which included a lot of employment discrimination cases. And that was while I was also trying criminal cases. My association with that firm lasted until Joe O'Terry retired, and my friendship has endured with all 3 partners since Mr. O'Terry has since passed. As a result of my civil work, I began providing pro bono legal services to a small nonprofit called Sociedad Latina, which is over on Fremont Street. I became a board member and stayed on for almost 7 years. During that time, I provided the board and executive director guidance on human resource issues, contracts, grants, employment-related issues. And Sociedad Latina had a unique mission and why I joined it. I trained young at-risk Latino youth to become peer leaders in their community, to actively take control of their lives and guide their peers to a more productive and positive opportunities. This program exists and thrives to this day, and I'm proud of the work that we've done with that, its growth and its success. I eventually developed a specialty in employment law along with my criminal work, which led to a teaching job with Harvard, where I ran the employment law clinic in Jamaica Plain. This was a hands-on law clinic for third-year law students who represented dozens of indigent clients facing discrimination in the workplace. And employment law became a significant part of my practice, along with some tort defense work. And I litigated cases against large corporations, nonprofits, cities, and towns. And after trying litigating cases for almost 30 years and working with a broad section of clients, and often battling in the trenches like a lot of you have, I'm now ready for a change in a life of public service. In this new role, my job will change, but my passion for law, justice, and equality will continue. I look forward to this new role if confirmed. While a judge is generally defined as an arbiter of justice and an interpreter of the laws, the role requires much more than that, as we know. A judge must be neutral, avoid the passions that may confuse and overwhelm others. A judge must not only balance equities, impartially and with reason, but also with empathy and compassion. Be fair and transparent. Have no favorites. Always seek the truth and aspire to do what's right. And if confirmed, I will be entrusted by you, the governor, and the people of the Commonwealth to uphold the Constitution and our laws while protecting the public and administrating justice fairly and impartially. And I assure you that my courtroom will always be open and accessible to all, regardless of background, that I will seek to set a welcoming tone steeped in professionalism and civility, that regardless of color, religion, sexual orientation, gender, or disability, every citizen who appears before me will be treated fairly and equally. No favorites, always transparent. If you choose to confirm my nomination, I promise you that I'll strive to meet the highest level of judicial professionalism, integrity, and compassion required for our judiciary. Always strive to do what's right. And I want to thank you for your time, and I look forward to any questions or comments that you might have.
Thank you very much. Counselor Eileen Duff.
Thank you. Great to see you.
Good to see you.
Great to talk to you the other day. I appreciate you stepping up to serve, because we know that so many of the great attorneys, which I think would be in the ranks of, can, do you need this? Can make a lot more money in private practice. So I, for one, greatly appreciate it. I am intrigued by your Title IX work. Can you share a little bit about that?
Yes, as part of my practice with Janice Basil, we handled a number of Title IX cases where students were accused of assaults on campus, and we defended, usually the young men. And it was in a system which at the time, which is prior to the new regulations that changed under the Trump administration, where it was very difficult to get access to materials, very difficult to be able to even put on a defense and investigate a case. You often were not able to talk to anybody, and were stonewalled. So we were dogged, and we were zealous in our advocacy. And I think we exposed some of the flaws in that. We were getting ready to do some significant appeals at that time, and then the new guidelines came down, which is unusual under that administration, that they came down with some guidelines. Some of them we can dispute as to whether or not they're appropriate, but it really made, I think, an attempt to make the system a lot more fair, and I think it has. And again, we can dispute some of them, but I think overall it's done that.
Great. I ask because so many people, especially women of my age, Title IX has one meaning of, sports equity and everything, and yet it is a big piece of law that I don't think many people understand. And so I find that quite intriguing. That
it's certainly an interesting area, and I know I will not have much exposure to it in the Superior Court since it's mostly federal. So.
That's all right. It's all life experience matters, right?
I agree.
It all matters because it helps form us to who we are. It's also, you come to this with a nice balance that you have civil in your background, and yet have done a lot of criminal defense, which of course we need. What would you say has been the most rewarding part of your legal career?
Well, I mean, I think I spoke to it a little bit on my in my statement, but working with Sociedad Latina all those times, and I've stayed in touch with them, and I actually worked with Jeffrey Sanchez on that. He was on the board of directors, and the impact on a daily basis with the youth was amazing. Seeing people change their lives, and building that program up from really, it was at the time was falling apart. We were able to build it back up and provide a healthy infrastructure for it. And I was legal counsel for them, so I was able to help them with a lot of their, kind of internal regulations and also some employment law issues, because the prior director was suing them because he'd stolen money from them and all that. But that's in the past. So that I really enjoyed. But also I think working, a lot of the juvenile work that I've done, as Judge Dooling mentioned, working with the youth and working on the developing area of law, which in terms of the brain development and how we treat, young, mostly men, but there's a lot of women too, how we treat them and that we understand that their brains are developing, and any of us who have kids understand that they're not always connecting the dots. And that goes the same for a lot of these young people who are being charged with serious felonies. So I think that's been Miller versus Alabama, and that whole explosion of case law, I think fascinated me, and I really enjoyed it.
Yeah, and it's, to me, we do want to hold people accountable for actions. It's not absolving them of a crime or bad action, but, does punishment fit the crime, and is there a better course of action than incarceration? Because we know that doesn't really work very well, particularly for youth.
And depending on the circumstances, you have to wonder if it's going to injure them.
I'm sorry.
If it's going to injure them in terms of if they're put in prison, depending on how old they are.
I think the evidence shows tremendously that it does.
So those are all considerations, absolutely.
Right. And, but it's good to hear, and good, as Counselor Devaney would say, heartfelt to hear that, again, it's not, we're not absolving people of making bad decisions and frankly, committing crimes. And frankly, there are people with mental health issues who, but we want to get them into programs, and in some of them, the issues may be far more complicated than others. But all the science is showing us, and throughout the world, we're actually a little bit behind with this. I think Councilor DiPaolo is far more an expert on this than I am. But, the greatest natural resource we have in this country is our children. And so whether we punish them or incarcerate them or try to help them become better people really says it's not about them. It's really about us. But anyway, I think you have a tremendous, resume, but also life work experience. I actually got quite a few calls about you from people who've opposed you in court, which I don't typically get those calls because I'm not an attorney. So that speaks volumes about who you are, that they reached out to me to say that this guy, really would be a great asset to the system. So I hope you're as good as you look on paper. And these people say you are, we have to, go with our gut too, but thank you for applying. I think you'll be a fine addition if the council so chooses to put you forward. Thank you, Mr. Chair.
Thank you very much. Councilor Terrence Kennedy.
Thank you, Mr. Chair. Before I start, I want to congratulate the chief on her appointment. She was doing a great job on the line. I appeared in front of her a few times. Very intelligent, very well balanced. I was concerned when she accepted the job that she might have lost her mind, but not sure why she would want it. Yeah.
Is it still?
But I want to start by saying I received a lot of calls from a lot of people that know you. I actually got a text a few minutes ago from Michael Royton saying you were an A+. Marty Weinberg called me. It's a very long list of very prominent lawyers that called me about you, many of whom I've known for decades and decades, and this for 38 years. I do have a couple of questions.
Sure.
Okay. And I'm going to follow up on some questions that Councilor Ianello asked earlier about technology and Zoom and all of that. One of the things that I have found, and I agree with what the judge said about the camaraderie that develops, that we develop as we practice law and interact with people like Ian over the years, and different DAs, many whom turn into defense lawyers later on. And there's a certain camaraderie that develops over the years, and I think that's going to be lost a little bit with the technology for young lawyers. I've been doing it, and Councilor Jubenville and I have developed relationships over the years. I think that's a loss, but I also think there's a tremendous benefit to it. When I'm sitting in my office and I have 3 pre-trials down in Plymouth District Court that I would be down would get back to my office at 2:00 in the afternoon, as opposed to being done with that by 9:20. That means that I can now get ready for the hearing I have tomorrow before Judge Boudreau. So he won't be mad at me that I need to continue it. So there's a big benefit to that, with respect to that part of it, not just for civil, but for criminal as well. Do you think it's necessary that a defendant be in court for every single appearance?
For every appearance, it would depend on who who the defendant is, but my reaction is no.
Because I think, especially in the district courts, people, I get it, that some of the crimes, people that you'd be looking at would be facing more serious charges. You might want to keep a closer eye on what's going on, and the stakes are higher. But, you got somebody who's working, who might have a union job, might have a whatever job, and they have to keep showing up at every pretrial, at every non-event day, should we say. Obviously, if it's something eventful, they have to be there. If it's a motion to suppress, the Supreme Judicial Court's spoken on that. It's up to the defendant, that's basically. So, but non-event days where it's just the lawyers, even in criminal cases, dealing with whatever issues there are, do you think it's necessary for a defendant?
It's funny that you say that, because I was thinking the other day in federal court, they never require defendants to come in unless it's a hearing, an evidentiary hearing, or something, a trial. You're picking a trial. So my experience has been that that's been helpful, and I do think there's a burden on some of these defendants to make it to court. I know a lot of defendants who don't have cars, who don't have access to transportation. It can be difficult. It interrupts their days and their work schedule. So I think those are really good points, and I certainly would consider that moving forward and have those conversations with Chief Brigger.
What about lawyers? Do you think it's necessary if I have a pretrial conference in Suffolk Superior Court in front of Judge Dooling? Is there any reason that I can't do that from my desk on Zoom?
I personally have no issue with that. I do think, as you stated, there is a pro and con to it. The pro being efficiencies, the con being relationships.
Well, but relationships, I agree with that part of it, and I think there are other ways we can fix that.
Absolutely.
And I think they're equally important. I think that's what makes our system work, is that lawyers develop relations. You develop relationships with the other side. You develop relationships with other lawyers that you're working with. You develop relationship with court personnel and judges. That they get to know you a little bit better. But just in terms of busy lawyers trying to get a lot of work done, why do we have to spend a half a day sitting around Suffolk Superior Court listening to Mike Dooling all day?
Well, Mike David told me how much Jim.
There's not a reason to do that over there.
Mike Dillon's much funnier than me, but I think your point is well taken, that it's very efficient system, the hybrid model, especially for those types of hearings that you don't have to show up.
Okay, so I expect that the Chief Justice of the Superior Court is going to be setting up some committee on technology and how to deal with those type issues. Are you volunteering for that?
I will do whatever Judge Brigger seems fit for her to do once I get into the robe. So,
okay, you have a pretty broad experience. I want to talk to you about the civil side of things, because we very rarely get nominees before us that have done both. Okay, I do both. I do a lot of high-end personal injury work, and I do a lot. I'm in court on criminal cases every day. And so there aren't many people who do both. You've done primarily criminal, civil defense work on torts?
Civil defense, but plaintiff work on the employment law.
Okay, well, putting that aside for the moment, but in terms of the tort work, primarily getting hired by insurance companies?
No, actually by individuals. It's, as Mike said, I usually get referred cases where it's a criminal case, and there's some aspect of it is civil.
Yeah, okay.
And sometimes it does intersect with insurance companies. Insurance companies would hire me individually.
Okay. Have you tried a lot of tort cases? A lot of them don't go to trial. I understand that.
Very few of them go to trial. The civil cases I've tried are forfeiture cases.
I have one that I expect going to trial in a couple of weeks, because one of the law firms on the other side is a real pain in the neck. Nothing
Right.
personal, Joe. That's who he is. But have you tried any at all?
I've tried civil forfeiture cases, but I haven't tried any tort cases. No.
Okay.
I've come close.
Civil forfeiture cases, that was when you were in the,
That was in federal court.
Okay.
And those would be extensions of criminal cases where they'd have forfeiture of property or
Okay, so you're defending,
defending the
Okay.
client, yeah, the defendant.
fighting the U.S. Attorney's
Fighting
Office
the-
on the forfeiture?
Correct.
Okay. The, well, I think that's good. I think that's great that you have both, because a lot of judges get on the bench that are done primarily criminal, and they're immediately put in a civil session for the next couple of years, and they start out by saying, what am I supposed to do here, you know?
Right.
And I think it's good that you've done both. There's been a lot going on, you may have heard about it, and there were folks that work in the court that I consider heroes in the court that, you know, basically a part of the foundation of what we do. They're people I have a lot of respect for. That's court office,
Oh, absolutely.
okay? They help us with our clients quite a bit. Sometimes we'll have a difficult client and they'll calm them down when they're in the cell and things like
I have
that
that experience.
in a very gentle way. There's been a lot of noise made lately, and there's a lot going on that Council Ferrara raised in terms of what they've been going through at the academy. And do you know what has astounded me about that? And I'm directing this towards the chief, because I think she has to look at this, and I think the court has to look at it. As I've been going back to court, like yourself, over the last couple of months, and this has been an issue, I haven't walked into a single courtroom where a court officer, I know most of them in the courts I go, haven't come up to me and said something about it, and said how bad it is. It's just astounding. Every single court I go into, somebody approaches me and says, Terry, you know, we've been watching what's going on with that. Can you tell me what's going on? And they have some really, really bad horror stories that they tell me. Both not in terms of just what happened at the academy, but in terms of some of the stuff that's going on in their employment situation. Something you'd understand, having done some employment law. I'm just pointing that out. That was more directed at the chief than it was you, because I think something has to get done, and it's not my battle. But when it was raised, I cannot tell you, it happened to me this morning. Every single court I go into, somebody grabs me, some court officer grabs me, and they're glad that some attention is being drawn to what's going on there. It's a problem. Okay, now, I don't have a lot of questions for you. You have a broad range of experience. As I indicated, there are, I've gotten countless phone calls from a lot of folks that you know well and I know well. I don't know that we've crossed paths very much over the last 38 years that I've been doing this, but
We haven't, but I've certainly your reputation.
which is surprising to me, given the nature of your practice. But I know that Judge Dooling and I used to cross paths constantly for decades, as many of the nominees that come before us have. And his testimony means a lot to me. Somebody I have a great deal of respect for. And your counselor has been very supportive as well. I don't know if that has to do with the JP connection or what that is, but it's certainly, he's been very supportive. You're a home run. I'm voting for you next week. I won't hide that. Thank you, Mr. Chairman.
Thank you very much. Counselor DiPaolo.
Thank you, Mr. Chair. Good morning, Attorney Buchanan.
Good morning.
See if I can get my mic to stand up. So first, I just want to start with something that's tangential to you, and I understood from talking to one of your witnesses that it's possible that David Deacon is watching this morning. And he will not remember me, but I interned for him in my first summer internship at law school in the child abuse division. And with him and Nancy Hathaway, that was really an inflection point in the whole thinking perspective on the world, and without a doubt, my career path. So just a thank you to
Hopefully that was positive.
to David Deacon. I hope so too. Who knows? I wouldn't be sitting here, that's for sure. So, you know, your qualifications are there, your references are there. So I just want to dig in a little more on some of the comments you made around your perspective on some of the important issues in the Superior Court today. So the first one, and I think most important beyond qualifications, is the racial disparities that are in our justice system. So you're familiar with the Harvard study, I know, because we had a good conversation. So to set the stage, we have very identifiable disparities in our system. thankfully, in the district court, sentencing, controlling for context and factors is actually about the same, regardless of one's race. However, when you jump to the superior court, and by the way, and that may be true, but it conceals the fact that Black and Latinos are far more likely to be arrested in the first place, right? So the example I always give to context to you would be the kids at Northeastern who were smoking pot and the kids less than a half mile away in Roxbury, and who's more likely to end up in our system. But at the Superior Court, we see that
So screwed up.
the average is over 20 days difference, controlling for all context, for white folks convicted versus Black or Latino folks. And when we look at particular charges such as weapons or drug possession, it jumps to 120 something. I forget the number off the top of my head. It's egregious. And I'm wondering what your reaction to that is. And I wonder, as a potential Superior Court judge, how that informs your work.
Right, well, I have read the study and I'm familiar with the statistics and the fact that there are no objective factors that explain the disparities. I can't tell you what the basis for it is, whether it's whether it's that starting gate when people are charged, if they're charged at higher levels than their white counterparts, or if it's something else. I don't have that information. I'm certainly sensitive to it and aware, and whether it's implicit bias that's brought to the table by some in the judiciary, or whether again it's at the DA's level, or if there's something in the statistics that we need to be able to weed out a little better. I'm not sure, but certainly I am aware of it and will continue to be sensitive to it while I'm on the bench.
I get, what particularly concerns me, and I think we discussed this, is in the first place, twice as likely to end up in superior than district for when there's concurrent jurisdiction, which of course, as you know, opens the defendant up to potentially longer sentences, right? Just by virtue of being there. So, I know that implicit bias training is going on. I certainly think that's important. That's a human trait. Extends well beyond race. But I do hope that the Superior Court is taking a hard reckoning on this. We have the highest disparity between Latino and white incarceration rate in the country in Massachusetts. And we have the 14th highest disparity for Blacks in Massachusetts. And I want to jump to the juvenile court. We had discussion around brain development. You talked about that a little bit today. I want to point you to a case the SJC recently decided coming out of juvenile court, Glenny versus Massachusetts, where a 16-year-old female was held in contempt of court for essentially telling off the judge. And I wonder, your understanding of brain development, how would that inform your reaction to that? I realize you won't be in juvenile court. And secondly, what would be your standard for contempt? How thick is your skin?
Well, my skin is pretty thick, and I think I would take I would put it in context of who it is, as you said, the youthfulness, the age, whether or not there may be some semblance of mental health issues involved. It would take a lot to push me over the edge with somebody. It would have to be something that's willful, flaunting of the rules in a way that is, that's irreparable. But again, putting it into context, there are many factors that would mitigate against contempt. In terms of that particular case and a 16-year-old, I'm not familiar as much with the factual details of it, so I can't tell you how I would react to that. But I can say that youthfulness is an important factor to consider in that, because as you and I discussed, and we've discussed this morning, brain development is a huge factor in how how juveniles respond to situations, and we shouldn't treat them as adults. However, there are certain circumstances where there are juveniles who have developed in a more mature way, and we have to flush that out also. So it depends on the circumstance.
Okay. And so when those circumstances come before you of a 19 or 20-year-old, and the SJC in their decisions have acknowledged research saying 22 years old as a cutoff. Research I'm familiar with in my studies suggests that it's longer, especially for men, and also especially for people who've experienced childhood trauma, which evidence suggests exacerbates, or I should say delays, quote unquote normal development even further, up to 5 years. And so when a 19 or 20-year-old is before you, you know about brain development, you know the preponderance of mental health concerns that folks who are entering our justice system have. I wonder, in your discretion, as you were just speaking, where does it lie? Could you get a little deeper into like why that's different than a 35 or a 40-year-old? Do you look at them differently, or do you look at them the same?
Well, I think it's on a spectrum in terms of development. And certainly a 19, 20, 21-year-old, you're going to view differently, depending on the circumstances. You're going to view differently than an older person who has life experiences, who has, again, their neurological systems are better developed. So drawing the line right now, the legal line is at 18 years old. But in terms of my discretion, I certainly can consider people who are youngsters or juveniles, adults who are 18, 19, 20 years old in the brain development issues. But I would suggest that the probation department, I would use the probation department and look into some of that background to get a sense of who they really are, maybe do some testing or ask for some testing. Because science is important, and I think that can help, whether it be psychological evaluations or even neurological evaluations. I'm hoping that the lawyers who come before me will be encouraged to present that sort of material to me so that I can make those decisions properly.
I'm happy to hear you say that. Regarding mental health in our system, again, tangential to your role, but taking it into account, we know that we have the 4th highest suicide rate in the country among incarcerated individuals in Massachusetts. We know that Donald Trump's Department of Justice released a report alleging that the Department of Corrections violates prisoners' 8th Amendment rights around access to mental health treatment. I wonder, when you have people before you who evidence suggests, or maybe even manifestly in the courtroom, are struggling with mental health issues, how that impacts your decisions around sentencing and any other discretion that you're able to exercise.
Well, again, you have to weigh all the factors. I mean, there's public safety issues. There are, in the seriousness of the crime. There are many, many factors, but it is a mitigator. And depending on the circumstances, it might be a significant mitigator. If I were to believe that prison would be so harmful to that individual, and weighing that against, again, the public safety issues, that incarceration would not be appropriate. But I'd have to wait until the case is in front of me. But certainly, I'm open to those options.
Mm-hmm. And I feel really good about your nomination. We had a great conversation before this. I just want to read one of your responses from the application because it kind of sums up why I feel you're going to be a great Superior Court judge. You were asked to characterize your views on how discretion ought to be exercised. You wrote, I believe a judge has an obligation to balance the nature of the offense, the defendant's role and culpability in the offense, the impact on the victim, and any applicable aggravating factors against the defendant's personal history, mitigating factors, including but not limited to mental health, drug dependency, as well as rehabilitation efforts, et cetera. I really am impressed with your experience, and I think your perspective is what we need on the Superior Court. So I intend to vote favorably on your nomination. Thank you.
Thank you very much, Counselor. Next, we'll hear from Counselor Joseph Ferrara.
Thank you, Mr. Chairman. Thank you, sir. It seems to me like you've lived like 4 complete lives with your experience. I don't know how you fit it all in, but you have a remarkable resume. That's not always seen by us with all the criminal and civil experience combined. You and I had some good conversations, and I appreciate the time you took. I appreciate the pro bono work you've done. I appreciate the great things you've done in your life, and I respect the fact that
a man of your young age would want to go on the bench when he doesn't need great judges on the bench as opposed to going sailing off into the sunset. And you and I spoke a lot, and I was intrigued with your breadth of experience in employment law and civil rights law and torts law and the things you've done in not only state but federal court. And that brought to my mind the thing that Councilor Kennedy talked about, and which has been near and dear to my heart, about the Court Officer Academy and what's been going on there and the tragedy. And let me start by saying I have great respect for the trial court. I've been able to say yes to almost half of all judges on the trial court, and I think we've done a great job. And I have great respect for the SJC. And I just think this is a bad mark on the court, the way it's been going on. I was a police officer for 30 years. I was chief for 9. I was the president of 95 cities and towns, an organization of 95 cities and towns. I was on the executive board of the Massachusetts Chiefs of Police. I've been involved with the Mass Police Association, New England Police Association. I've been to the academies run by the state police. I don't understand what's going on with the academy for the last 5 years. And I know it's difficult for people to come forward. Most of these people that are discharged or assaulted or hazed don't have the means, and they're lucky to have jobs. A lot of them are now what you call associate court officers, the blue shirts. So they get thrown out of the academy and they're able to keep their job, making a small wage. But since I brought this to the attention of this council and to other people, my phone isn't blowing up. Like, I don't go to court as often as Councilor Kennedy, but every time I do, people are grabbing me saying, "Oh my God, I have a story." Not one person has said that nothing's going on. No one's on the side of the bad guys. And when I was a police chief, you know what I learned? You know what good cops want? Good cops. They want the bad ones weeded out. They really do. The other thing I learned is, as a police chief or as anyone in a position of power, there are 3 questions you're going to be asked someday. What did you know? When did you know it? And what did you do about it? And I think that's going to be asked to a lot of people going forward. When I went to the Azores and I taught some law over there some years ago, I was amazed that the difference in the law. And we went over there and we tried to teach them about restraining orders and how it would work and protect mostly women. And talked about how things work in our society. You have a bad cop or something goes wrong, working under the color of law, 3 things can happen, I think. And I'll ask you if you agree with this. There's an administrative thing where you can be suspended or fired, correct?
Mm-hmm.
There's a criminal component where you could be charged. And there's a civil process where you could be assessed money damages. It doesn't happen that way in Portugal and doesn't happen that way in other countries, but I'm glad it happens that way here. We have talked in this chamber, I have mentioned names of people who have assaulted people, outright slapped them in the face, and I have witnessed to prove it. And my understanding is those people are still employed and working today. It's not a decision I can make, but it bothers me. And I'm telling this publicly because a court officer called me yesterday and said they looked at our YouTube video from last week and we had 500 hits on it. I don't even know how to do that. I don't know what it means, but I can tell you this. My phone rings after every meeting and I'm getting emails from court officers talking about, geez, thank you so much for doing this. Thank you for bringing this to the forefront. I did have a conversation with Chief Justice Paul Carey last week, and I laid out a lot of the complaints and grievances and problems that have been brought to my attention. I laid out the fact that I didn't think it was proper that the Director of Security, Mr. Morrow, was on the board to choose who's going to investigate him and his department. I have an issue with that. She assured me that a couple of firms had applied and that there were more than Mr. Morrow on the board. But I think it's an issue. I have heard from so many people some of whom made it, some of whom were chief court officers, some are assistant chiefs, some are court officers now, some are associate court officers, and some are civilians because they got thrown out of the academy. And the one thing that is in all of their voices and all of their statements is they're deathly afraid of retaliation. So I'm hoping that this investigation, when it goes on, And I'm told by the chief it's going to go on soon. She assured me personally that there would be no retaliation and that the trial court will protect those that come forward. I was happy to hear that. I can't tell you how many, I think, lives have been ruined. People usually stay at the academy, you have to live there for 8 weeks. Usually in their 7th week, they're discharged summarily. They're escorted out by 4 to 6 people. Go to your room, clean out your room, get to your car, and you're escorted off the federal air base. Do you think, in your experience, that having a Massachusetts trial court on a federal basis causes some problems for people who want to address or have redress in the court system?
I'm sorry, could you repeat that again?
Sure. Do you think that the fact that the Massachusetts trial court
Mhm.
has their academy on a federal air base raises some complications for people who want to have redress in a Massachusetts trial court?
In terms of jurisdictional issues, I mean, I'd have to research that issue if that's what you're asking. But it's something that I think the court needs to deal with. I mean, as we know, the court officers are an enormous resource for the Superior Court, for the court system, important to our function on a daily basis, and a lot of wonderful people. So I'm sure that the court, even though I haven't been involved in this, I'm sure that the judiciary and the chief are going to put the resources necessary to look at this and to make sure, that it's corrected. And if, I don't know if a case like that ever came before me. Obviously, I would have to research it and spend the time, figuring it out. I can't give you a specific answer at this point, though.
I can tell you that I've talked to several agencies that are probably going to be involved in this going forward. But my question is, and I'm told by people high-ranking in the state police, they don't believe they have jurisdiction now. You see there's a problem that the Massachusetts State Police can't investigate issues at the Massachusetts Trial Court Academy?
Well, hopefully there's another agency, whether it be a federal agency or some other agency, that would be able to take their place and do an adequate investigation. But again, I don't know why they've made that statement or why they've come to that conclusion, and I can't really comment on that at this point.
So as a police officer, I can tell you 99.9% of all investigations in my 30 years in any department that I know of in Massachusetts are done by the local police or the state police, because the federal government doesn't have the resources to investigate all this stuff all the time. So I see having a Massachusetts Trial Court Academy on a federal ground as a potential problem with it if the state police have no jurisdiction, because they're insulating themselves from investigations. That's what they're doing.
That will have to be looked at as to whether or not it should be moved.
And what about when a high percentage of every class goes for treatment because they burn their retina, because they don't have the right medical care after they're told to open their eyes wider and talk more while they're being sprayed down with pepper spray? How do you obtain those medical records from these people?
I think that's a complication.
Because it's on a federal property, correct?
It seems to.
And what about the people that organize these academies? Do you think they ought to be credentialed to organize these academies?
Yeah, I don't know what the credentialing is for these academies. And certainly I would suspect that there should be a high level of oversight on them. If that means certification of some sort, then that would probably be appropriate.
Do you see any utility of telling people, these people that have lived there Monday through Friday, to go to their cars at 4:30 and they're all dressed up because you have to dress up to go home, and then have them crawl across the parking lot for another 2 hours on all fours and doing push-ups and sit-ups and antagonizing them for another 2.5 hours to leave at 7:30 at night, 7:30 at night? Do you see any utility becoming a court officer doing that stuff?
Not personally, no.
Do you see any utility in choking people out almost to the extent of being unconscious? Because that's what a letter I read last week said, from a female court officer who's been on the job for 5 years. She was choked out almost unconsciously and was told, you need to know how that feels to be a court officer.
I think these allegations are serious and need to be investigated, bro.
Well, I appreciate your comments. I appreciate all your work. And anyone who's watching, if you want to get in touch with me, I'll put my email out here right now. It's jferreira@lynchlynch.com. I'll give you my cell phone number. It's 508-663-6584. I will point you in the direction of, and you don't have to call me. You can call your state rep, your state senator. You can call the attorney general. You can call the FBI. You can call the trial court. But please come forward and know that you're going to be protected. There won't be retaliation. I liked your comment when you said it's not about being a hero, it's about doing the right thing. And I'm hoping that people are going to do the right thing about this very issue. Thank you, sir. And I'll be voting for you next week.
Thank you very much, Counselor. Counselor Robert Juvenville.
Thank you, Mr. Chairman. To follow up on that topic, since Councilor Ferrera has been so diligent in exposing what's going on out there. Having been to 2 boot camps in my lifetime, half of what I hear that goes on out there, if half of it is true, in my view, it's a disgrace and the place should be closed immediately. Having people trained in certain ways, you can do it in a way that is realistic to the function they're going to perform, or you can do it in a way which evidently is the way they're doing it. What you produce out of a boot camp like that are people who are aggressive, physical, and I think it produces a certain amount of bullying in people that are inclined that way. And I don't think the need for that kind of a person in our court system would enhance the system. Yeah, now and then people act out. But in my years, the court officers were pretty good at de-escalating that stuff, calming people down. In one instance, I saw a client of mine stand up in a superior court objecting to a thing a judge was doing, and about 5 court officers tackled them. Tables got knocked over, chairs got knocked over. All the fellow did was stand up and say something to a judge. I think that kind of stuff is inappropriate. And you produce a person who is going to have a lot of issues, I think, down the road in the court system by being abusive to people. And I don't think it should be called a boot camp. If it officially is, it should be a training process that you go to. Yeah, you learn how to take care of yourself a little bit and how to handle people that are aggressive. But other than that, you should be in a classroom learning about what goes on in our court system. How to treat everybody that's in there with compassion, dignity, and sympathy. So that's my take on it. I think it should be closed immediately. You know, I think you're a great candidate for the Superior Court. I'm going to vote for you, but I'm going to ask you some questions. Just different things that I pick up on. How is it in the Superior Court that, unlike the District Court, where if I want my client to plea and he wants to plea, I go to a sidebar and the judge says to me, I won't go over the Commonwealth's recommendation. I say, okay, but why are they getting the special treatment? District Court, I can send a feed into a judge asking for a certain disposition. Judge can either reject it or amend it in some. So I don't know why. Sure, you've heard it many times. Why the Commonwealth gets to be the sort of the control over how much time somebody's going to get. I know it's something to think about when you're sitting on. How do you feel about guidelines?
Well, guidelines aren't managed. I don't think.
I hear that from everybody, but every time I'm in a Superior Court, I hear guidelines.
Well,
I hear guidelines.
let me say
If
this.
it's good for the government, they're guidelines. If it's good for the defense lawyer, it's guidelines. And I'll use, let's say somebody says the guidelines is 5 years. It's always the starting point of the discussion.
And, you know, I've had a lot of experience with the federal and I know too, in terms of the federal guidelines. And again, there's very little science to support those guidelines. They use it as a reference point. And the court says it's the reasonable, you have to use it as a reasonable point. In the state courts, we don't have to do that. We don't have to defer to the guidelines. I think on occasion, there may be some value to it on occasion to just get a sense of what a sentence should be when you're like, you know, really, where do you stay? Where should this be? But again, what is the basis for that recommendation in the guidelines to begin with? And that's what I'd want. And I don't know that there is any scientific basis. If there's a compilation of sentences that this is the mean on, I don't think that that's necessarily where this information comes from. So with that said, I think I would use my discretion. And there are a lot of variables that come into that. And those go from, you know, the role in the offense, the seriousness of the offense, the impact on the victim. But then on the other side, of course, we have the mitigating factor, youthfulness, whether or not there's been rehabilitation, whether or not, you know, there's any mental health issues, so on. So I think it's a combination of all those factors that come into play. The guidelines are, you know, I won't say a sideshow, but aren't as important as they would be in federal courts.
Well, you remember the days of the federal court mandatory guideline
Absolutely.
and the damage and destruction that was done to citizens in this country.
Right.
Why anybody would ever think to bring guidelines into our system after what went on down in that building down by the seaport, to me is absolutely amazing.
There were devastating years where people would serve 10, 15, 20 years being, you know, half of them kids. And now those same sentences without the guidelines are, you know, quarter, if sometimes probation for the same individual, because now they're able to assess the total package of that person, to assess who they are, as well as the offense. Whereas before, it was just a number you had to give. And, you know, again, the legislature has control over that. I don't have any control over what the legislature does in the future. But I think judicial discretion is critical to fair sentencing in the Commonwealth.
Well, what I'm told is, well, we've got to get uniformity in sentencing. And that's what these guidelines are supposed to do. But to me, no two people are alike. No two people should get the same sentence. A person in Boston that commits the same crime in Springfield, there may be different factors, a whole lot of different factors. And to say we're going to make a guideline for what somebody should be. First of all, I think it's illegal. Only the legislature can punish a crime in this Commonwealth. But to say that we're going to use this so that there's uniformity in sentencing, well, guess what? We don't need you. We don't need Mike Dooling. After the trial, we just put the guidelines into the computer, spits it out. You go. Why do we need a judge? The guidelines are supposed to be taken into contemplation and used. I don't get that. Anyway, are you familiar with the Farouk scandal out in Western Massachusetts?
In terms of the drug testing?
Yeah.
Oh, yeah.
So did you read Judge Carey's decision?
Cotty decision, is it? Is that?
Yes.
Yeah.
Yeah.
I've
Yeah.
read, whether I've read every footnote, I don't know, but I've certainly.
No, but there's a section in there which I've never seen in my entire life a judge make statements like were made by Judge Carey about the disgraceful conduct of the prosecutors in that case. And he went on and on about it and the damage it was done to people by what they hid, lied to judges, sent letters that were false judges. And even when it was over, they still took the position that what they did was right. But I've never seen a decision like that written in my life. And I hope that if you're on the bench and that happens to you, you'll have the fortitude to write a decision like Judge Carey wrote.
Like I said, I think the most important thing, one of the most important things of being a judge is doing. I think sometimes it takes courage, but sometimes it's just what you're supposed to do.
Well, you know, the only way these things stop is by judges that take a firm handle to it, write about it, and other agencies go at looking at the thing. But what was done out there was a complete, it was illegal. He called it illegal.
I think Brady violations are,
And
have to be taken seriously.
so keep that decision in your, when you're moving around.
Thank
You've been in prisons and jails over the course of your career.
Quite a few.
You know what it's like going in there.
My son says to me, says to his friends, "Do you know my daddy was in jail today?" They all get a laugh out of it.
Because sometimes I think it should be mandatory that every judge in our Commonwealth, every prosecutor in our Commonwealth, or anybody that can make a recommendation about jail should know what it's like. You know, prosecutors throw out numbers and look at them and I go, they remind me of the recruiter when I got drafted. They try to sell me on a special unit or a nice uniform, but you have to join for another year. That was the rub. And it sounded pretty good when the guy was talking to me about it, but then I thought, a year? So I didn't bite, but a lot of kids did. But you know, jail time is explained to me. A day is like a week's like a month's like a year. You know, and being in the prisons a lot over the years, senior correction officer used to say to me, "There's nowhere to hide in these. Somebody wants to get you, they're going to get you. You spend every day surviving." I know there's not a lot of sympathy for inmates, but if we're going to keep people locked up, they ought to be at least assured that no harm is going to come. I like the fact that the people that come here have been in those prisons and seen what they're like. So you were asked a little bit about the racism in our court system.
Mhm.
And you've read some of that Harvard study that Reg Gantz commissioned. So I get to the feeling that it's a lot more deeply embedded than we all realize. And we may have, and we've grown up that way in our system, but we don't even think twice about it. But a lot of what was done in that study, and a lot of what's done in our court system and incarceration, the only explanation they gave was racism. No other explanation. It was racism. And I fear that it's still heavily embedded into our court system in our lives, because it's been there all along. You take looking at somebody's record and sentencing them based on their record. Well, the kid in Dorchester, Roxbury, the minority kids, they're more than likely going to have more of a record than the white kid in Wellesley and Longmeadow and Cohasset. So they get punished heavier for that. And I don't know about you, but I don't think that's right. I grew up with, if you get punished for something you do, when you're done with that punishment, that's over. It's over except for our court system. We're going to sentence you again to more time because you've had a prior. What do you think about that?
I'm sensitive to those issues, and I think there are a lot of variables that can come into play in terms of a person's criminal history. You know, how long ago were the other convictions for? What was the type of conviction? What were they? What were the substance behind those convictions? I think all those have to be taken into consideration. But
Why do we have to use the precedent thing?
I think part of it depends. Part of it can't. Well, for example, I'll give an example. If someone had a hands-on, child molestation and they've committed one previously, that would tell you something about the person, correct? But in some circumstances, if you're talking about marijuana use and then, some of the things such as unruly behavior and so on, those would be less instructive of where a person is going. So I agree, but I think you do have to, you do have to look at it deeply. You have to look at it behind just the record itself, which often you can do in federal cases, and you can do it in the state courts. I don't think people take the time to do it. And I think your observations are helpful, and I'm sensitive to that.
Even the guidelines. If you have a prior, you go to a higher sentence, right? Well, for the minority people in our Commonwealth, outweigh the white population in the prison. Guess what? They're all in there because the judge sent them there. Whatever he used or she used, they're there because the judge did that. So you get punished more if you're a minority because you interact with the police more often in those communities. And you don't get the leeway you would get in the towns like Wellesley or Long Meadow. So to me, I don't think it's fair to use it. And I've done it all my life. I've used it all my life. But I'm getting to the point where I think that should be looked at again.
I'm open to, those arguments and discussions.
So the governor says no more masks if you're vaccinated. I can go to any state agency in this Commonwealth and I don't have to wear a mask except one, the court system. And I've been told, well, I said, you're got all this plexiglass we spent millions on. They said, but the disease goes up over them. I said, well, then why do we put them up in the first place? But I don't know about you, but I don't know how anybody can have a trial in this Commonwealth or a motion to suppress with live witnesses where a witness is wearing a mask or he's on a Zoom. I did a hearing, which I objected to, but we had to do it anyway, where it was a dangerousness hearing where the police officer was on the video, the DA was on the video, I was in the courtroom, and the police officer was speaking, but always looking down and speaking. So I know he's reading his report, which he's not supposed to do. And the DA was asking questions, and then the DA was looking up over. Obviously, somebody was behind the screen, either with a whiteboard or whatever, kind of helping the DA out. And I said, I don't think that's fair, but Judge, well, my thing is, what would I do as a judge? I'd say, we're not going to have a hearing like this. No, we're going to have people come in here and have a hearing. But hopefully the court system will, I was in Rentham Court recently. I was talking to the clerk and I said, geez, you can only bring in so many people in this building. You got to be separated. You got to wear masks. I said, I can go down to Gillette Stadium and sit with 50,000 people, shoulder to shoulder, and I don't have to wear a mask. What does it do if you can do that at Gillette Stadium? Why are we doing it in the court? What value is it? Are we saving anybody when everybody else doesn't wear a mask anywhere other than that building? So as a judge, I guess you have discretion to have the witnesses not wear masks, I think, for a whole reason. And the lawyers don't have to wear masks when they're questioned. So how would you feel about doing a trial with somebody that was masked?
Again, I think it would be optional for the witnesses, but I would, my position would be, but as long as we're not required to do it, you don't have to do it, and I would prefer not to. Because I do think the mask does cover facial features and does impact our ability to kind of perceive the witness in a way that's helpful. Absolutely.
Well, you know yourself. I mean, we have developed since we started walking on the earth to look at facial signals to determine whether somebody either likes us or doesn't, or whether somebody might be lying to us.
Agreed.
And to establish the credibility of a witness on the stand, I don't think any judge can do it with this.
I can't comment on other judges, but I know it would be my
And the jurors also. How many times during a trial do you look over at a juror, you see him rolling your eyes and you go, I better move on to something else, right? So they give signals by things that are helpful to us. So if a lawyer objects to going to trial or having a hearing with masks, would you allow them to do that?
I can't comment on something that might be in front of me in the future, but what I can say is that my preference not to.
I know, but let's say, told you gotta have masks.
If I'm told,
Yeah.
Okay.
And I come into the court and we're supposed to go to trial, and I say, Judge, I would object to going to trial if the witnesses are going to be wearing masks.
I'd have a problem with holding a trial with witnesses.
Excuse me, can you speak up just?
Oh, sorry. I would have trouble with going forward with witnesses wearing and jurors wearing masks if they were required to do that. I think that would be a problem, and it's likely that I would continue the case.
I would hope.
Yeah.
The other issue is for the governor's counselors here that go to trial, that go to courts. On Wednesdays, we usually sit here. And thankfully, when I've been on trial, a whole bunch of different things, Superior and District Court, the judges have allowed me to come to the council. So you're sitting and I come in and I'm going to start a trial. And I say, but next Wednesday, I've got to be at the council. So can we just let me go to the council, keep the trial going, but take that day off? How would you feel about that?
I wouldn't have any problem with that.
Like that? Good.
I think judges
In
have.
fact, I think for the general assemblies that that you can't be stopped from coming here, like the reps and senators on the way to the legislature, you can't be stopped and detained, so you wouldn't be able to get here. I think that applies to us then.
We'll see.
How do you feel about minimum mandatory sentences?
I think minimum mandatories are an unfortunate legislative enactment. I'm not in favor of them. I think that that judges should have the discretion at every level. But it's a separation of powers issue. The legislature has deemed it appropriate. My job as a judge is different than as a lawyer. I unfortunately, under those circumstances, would have to impose the minimum mandatory. Doesn't mean I like it, but I think again, that's a separation of powers issue, and I can't really do much about it.
Well, there was a judge that did something about it.
Mm-hmm.
And he was pretty courageous in my view. And the fellow was facing a 10-year minimum mandatory, and she knew it was totally unjust. He said, I am not sentencing him for that. I'm sentencing him for whatever, let's say 2 years. Now, it got overturned, obviously. But if enough judges did that, had the courage to do that, because you're not going to get fired if you do that. You're not going to get punished. You may get transferred to some other court, but they'll love you in that court too when you show up. But she sentenced them to non-mandatory to give a message. And I think if every judge or most judges in the Commonwealth did that down the hallway, they'd take care of that. Continue without a findings. They're doing more of those in the Superior Court now. What's your feeling on those?
I think it's a great tool in the judge's toolbox. So you would have to, it would depend on the circumstances, but it's a real option, and I would exercise it when I thought it was appropriate.
Yeah, because sometimes, as you know, some clients, there's no way in this system for somebody who is truly innocent and has been charged, there's no way out other than pleading for going to trial and risking a guilty and going to jail. There's just no way out. Unlike the divorce, they'll allow no fault. Before that, everybody had to lie about what went on in the marriage to get out of it. And everybody knew they were lying. So there's no way out, but sometimes the bugaboo for clients is having to admit you did something. And if the penalty is going to be the same, probation is going to be the same, or whatever else is happening, what's the difference if you just don't make that statement? You're there, you're taking responsibility, but you're just not saying that. Because we know 10 to 15% of people convicted are innocent. They get out 20 years later. You know that. So I don't thank you for that anyway. I like the fact that your father taught you compassion and empathy.
A good man.
I think that's the greatest quality of a judge. I think if a judge doesn't know any law, but has those qualities, he'll be a wonderful judge. So anyway, thank you for letting me go on and on. I think you're one of the best qualified people we've ever had here for the Spirit.
Thank you, Counsel.
Thank you.
Thank you very much, Counselor. Thank you. Just to let everyone know, it's 10 or 12. The Lieutenant Governor should be coming in, give or take, 12 noon. At that point, we will have our General Assembly. Today it should last, give or take, 10, 15 minutes. I would say we're not going to finish before 12. So once we break for the Assembly, let's look at it, say, an hour after the Assembly is over. So we're looking at 1:10, 1:15 to resume. But at this point, because we never know when the Lieutenant Governor comes in, she's pretty prompt, but you never know. At this point, I'll hear from Counselor Marilyn Petito Devaney.
Thank you.
Thank you, Counselor. It was a pleasure meeting you,
As was.
and all the time that you afforded me. I really appreciate it.
Thank you.
And because I meet with everyone, I want to know the whole person, not the person on this paper. And I got to know your family and how proud you are of them and your involvement. I think right off the bat, I am going to, in respect to Janice Basil, for you to know.
My
she
partner
was
of many years.
Heartbroken she wasn't here. Dear Governor's Council, I write this letter with sadness that I could not be here today. I had an in-person court hearing that could not be rescheduled. I understand that Counselor Devaney will read this letter, and I am grateful for her willingness to do so. I have known Jim Boudreau for almost 30 years when I first moved to my current office address. At that time, Jim was working with O'Terry and Weinberg, and I often went to him for advice on cases. Over the years, I came to appreciate Jim's intelligence, mastery of the law, and providing his time for my questions. In time, Jim came to work with me, and for the last 8 years has been my law partner. What can I tell you about Jim that you don't already know? He is kind, thoughtful person. He is the one of the calmest people I know, even when preparing to defend a first-degree murder case. He does not have the ego that often goes with someone with his qualifications. He is ineffably polite and respectful. All of these are, I think, important qualities for a judge. I have often turned to him for advice and thoughtful considerations of issues and cases. We have had hundreds of discussions about evidence, law, trial strategies, and most importantly, for your consideration, discussion of the right thing to do. We have talked endlessly about appropriate rulings and sentences, judicial behavior, temperament. I have complete confidence that Jim would be one of the finest judges you could appoint. As lawyers and As lawyers and facts and cases appear in a nerve-ending river of issues, I think it is important that a judge be first and foremost a decent person with a fundamental sense of fairness. I have no doubt that Jim is a person of strong principle and high morals, and yet he has the ability to recognize that not all people have the same advantages in life. He will temper his decisions with appropriate compassion for all involved. Jim is a problem solver who will take a complicated issue and look at it from every aspect until he finds a solution. He certainly has the knowledge and skills to manage trials, and where possible, will work towards a fair resolution. As I write this letter, I realize how much I will miss Jim if he becomes a judge. I also know that he will be one of the best appointments to the bench.
Thank you.
I remain available to any of the council for any questions you may have. Very truly yours, Janice Basil. So what has been said about you from your witness saying you're a decent person, honest, I mean, you know, this is beautiful. I'll mark it up. I'll give you a copy of that. So, you know, I talked about writing because I'm really concerned about that, the need to have judges who can write. I was very interested in your writing. I don't know whether partially, my late husband was a firefighter, and this was about a fire. And you found it that the findings were not based, the causes of the fire were not based on, they were just based on assumptions and unreliable data, and they didn't really do the job. And we're talking about a murder and a robbery that's involved in all of this. So why don't you, for the public, talk about the writing that you submitted?
Sure. That was in Commonwealth Melendez, which was a homicide case where there was an arson that was attendant to it they were alleged to use the arson as a means to hide the actual homicide. And we brought in witnesses for that purpose to countermand it, and had an expert who identified a number of other possibilities, which were the source of the fire itself, and ultimately determined that they had thrown away all the wires, that the government and the fire marshal had thrown away all the wires that they said were the start of the fire, where he supposedly poured some gasoline on them. And that led to a ruling by the court that they had engaged in what we call spoliation. So that particular evidence was not permitted to be entered at the trial, which was obviously significant for my client. But in terms of the writing, it took us a long time to become essentially an expert on the issue of arson, on the issue of accelerants, and so on. And I spent months really trying to.
Was the fire inspector involved in this? Because they go out to all those.
The fire inspector went out to the scene, and was just unfortunately in this case did not follow all the rules and regulations, and as a result, he really tainted the whole investigation.
Mm.
So yeah, that was a significant piece of writing that you've picked out there, and involved testimony from voir dire of the witnesses that went on for hours and hours and hours.
And the result? For people to know.
In terms of the case actually was ended up in a mistrial. The jury was deadlocked. They did acquit my client of robbing the person, but there was a mistrial, and we actually tried that case 2 more times.
In the murder?
The murder was a mistrial.
Imagine. Now, how many hung trials have you been involved? Are there very many?
Oh, I've had probably 8 or 9 hung juries.
Right.
So
Right. Well, You
Which
know,
means you have to try the case again,
right.
which is no fun for anybody.
Well, I did want to mention, been here 21 years, and I have never seen, I have to get back to these two answers that you gave. I've never seen anyone answer them so honestly. And really, I just appreciate your, your ability to do that. You're asked what the strength of the court is. And you said the ability to correct legal injustices and seek the truth, whether in a civil or criminal case, rigidly applying the rule of law defeats public confidence if the process used to attain the outcome appears biased or lacks transparency or balance. The judiciary has all the tools to instill confidence in the public as long as the judge is fair, experienced, and resourceful. And this is very meaningful, what you said next. As a judge, I intend to work with other colleagues in an effort to reduce real and perceived bias and to increase transparency in the court system. Can't say better than that. Now, I've never got an answer like this to the question, the greatest challenge in the court that you're applying to, Superior Court, and how would you address it? And you said beyond limited resources, a lack of judicial temperament and a public perception that the court is inefficient, biased, and represents the interests of the powerful and politically connected are the biggest challenges facing the court system. That was a brave answer. You're the first one in 21 years that ever said that. Every effort must be made to root out bias and maintain the integrity of the judicial system. Due process and transparency is essential if the court wants the public to perceive that the system works for everyone, regardless of race, ethnicity, political connections, or economic status. A balanced judicial temperament towards litigants and lawyers alike is critical throughout the judiciary so that every participant believes that the system is reasonable, consistent, and fair. It also is critical that we develop processes to make the judicial system more efficient while increasing engagement with all participants. And then you go on about transparency and sensitive to racial and cultural differences and respect of all. I have never seen it, and I am just so impressed. And I was impressed meeting with you and knowing, what your philosophy was. And, you're asked to, they have changed, they've added some questions that they didn't have, some months ago, and they've added the Judicial Nominating Commission on their questionnaire. And they want you to talk about, talk about your qualifications. What significant qualifications do you have? And you said you've worked on mega discovery cases. And, I mentioned someone, Salem Rodriguez, 6 cases, and he was confirmed to be a Superior Court. And you have had mega cases. And when I've asked you, you couldn't even tell me how many cases you've had, hundreds and hundreds. And you've crossed between civil and criminal cases throughout your career. And so you have insight how trial lawyers function on a day-to-day basis and talk about litigants and defendants and lawyers. And then you talked about that you've been involved in the federal system regarding inpatient, outpatient, and this is what I want to get to, substance abuse. Right. I mean, we know judges 50 years ago didn't deal with the major problem is drug addiction. Tell me your experience.
Well, in terms, obviously, I think the science around this is developed in a way that shows that, addiction is a disease. And that's a factor that we all have to take into account. And that a lot of the clients that I've seen who've gone into the system hasn't had, and the state system hasn't had the resources to deal with their circumstances. In the federal system, they've had some, and there's a lot more. And I would like to see this sort of thing happen in the state system. And I know it's happening in the drug court, and there's a lot more attention to putting people into programs. But there's one program in particular, and some of the federal prosecutors who've been appointed are aware of this, called the RISE program. And it's a complex program that it uses all multi-factored programs to deal with addiction, but also to make sure that people have what we call restorative justice. So they get involved in understanding what their actions the impact their actions have had on the community. And as a result of all that, some cases end up being dismissed both in union with the prosecutor and the defense and the court. So there's a lot of benefits from that. So I agree that I think the world has changed. I think most judges are aware of the fact that addiction is a disease and that it is a mitigating factor that we all have to take into account for all cases.
Well, I've been lobbying for years to have more, drug rehabilitation centers. I think we only have 3 or 4, and for women, there's only one, Framingham. And men don't want to go to a prison, Real Rico. And so is there anything you as a judge can do to lobby for more rehabilitation? Because, it isn't enough just to send someone off for a weekend or whatever. And I've said it before, I have 2 close friends who lost sons overdose on heroin. And they tried, and they went to these places, and it's just temporary thing. And my friend, one of them, she had gone to all kinds of classes and everything. So they've done everything, but there's not enough to, and these aren't bad people. These aren't criminals that get addicted,
I think in terms of trying to find other alternative programs that would be available, I certainly would work with the probation department as well as with the chief justice to determine what options we do have and utilize the judiciary system to maybe lobby the legislature to appropriate more funds. But I'm not sure what I can do personally
It's like
beyond that.
1% of the budget.
No, I
the
understand.
judiciary, you know that. So it's like
difficult.
the bottom.
I'll have
rung
to
of the
explore
ladder.
alternatives. I mean, I have a wealth of experience in that, and I'll use that to try to pursue alternatives.
Oh, good for you. Now tell me
Excuse me. We are going to break. The Lieutenant Governor is going to be starting the assembly in about 1 minute. You folks, if you want to listen and watch the assembly, you may. If not, it looks like we will resume at 1:20.
120.
Thank you.
Great, thank you.
Stay. It'll only be about 2 minutes. You want to stay?
We have a special guest here.
We have our nominee and his son, Governor.
Okay.
They're leaving us.
Mr. Boudreau and his son and his wife who are here.
Hello.
We're finishing up their hearing.
I'd love
Introduce
to
your
know.
son.
Tell me
You're being
about our
introduced.
youngest
Yes.
member
Yeah,
here.
James Boudreau, if you remember, and this is my son, Ethan, Ethan Boudreau, and my wife, Donna Griffith.
Well, welcome to
Assistant
the
County Governor.
State House and to the Governor's Council chamber. This is a
Thank
very special room and important
Certainly is.
place. And you look the part today, making your mom proud for sure. Where do you go to school?
The neighborhood.
Jamaica Plain.
Right? And what are you doing for fun this summer?
Good answer.
Basketball.
Every day.
And making up for a really hard year for you kids. Really hard. So I'm glad that you're having some fun, playing your sport, doing your job in school. So, thank you.
Thank you.
We're going to start our meeting. I
Pleasure.
know the members are anxious to get going. So we'll call our assembly to order, and I call upon Councilor DiPaolo for our prayer and pledge today.
Thank you. Today, I'd like us to offer our thoughts and prayers to the too many victims of gun violence in my city of Worcester and throughout the Commonwealth. And pray that that comes to an end.
Amen.
I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Lieutenant Governor, before we start, I have a statement to make on the record.
Can we do our official business, please, Councilor
Pardon me?
Glenny? We're going to have our official business, and then you can read your statement.
Okay, thank you.
Call upon Councilor Hurley for a motion to record advice and consent for the financial warrant.
So moved.
There's a motion and a second. All in favor, say aye.
Aye.
I call upon Councilor Duff for a motion to record advice and consent for the pending list of notaries public and justices of the peace.
So move, Governor.
Second.
There's a motion and a second. All in favor, say aye.
Aye.
I recognize Councilor Kennedy for a motion to record advice and consent for the appointment of Karen S. Fabiszewski, position of Administrative Law Judge of the Industrial Accidents Reviewing Board for a 6-year term.
I make that motion with pleasure. A fantastic nominee.
Second.
Can I,
There's a motion and a second. Councilor DeBanny.
I think it should be noted that we don't see this, but on the joint bar, they deemed Karen well qualified. We don't see that with a new person coming on, and I think that should be in the record. And she's been there 20 years. She has all the experience. I got more people that know her, and we've never had anyone with that much experience. Thank you.
Thank you. There's a motion and a second. We may begin the roll call.
Yes.
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 Thank you.
I'm also a yes. That's okay.
Okay. I recognize Councilor Jubenville for a motion to record advice and consent for the appointment of Timothy Dooling to the position of Administrative Judge of the Industrial Accident Board for a 6-year term.
I do with pleasure. He's a great candidate.
That's a
I second that.
motion and a second. We may begin the roll call.
Yes.
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 No.
Yes. Yes.
Yes.
Thank you. I recognize Councilor Jubenville for a motion to record advice and consent for the appointment of Michael Sherry to the position of Administrative Judge of the Industrial Accidents Board for a 6-year term.
I do so. Another good candidate.
There's a
I
motion-
second that, and I'd just like to say that,
There's a motion and a second.
yeah, I mean, outstanding qualifications, experience. He has criminal cases that I think is very important as much as the civil, and just a good person, compassion, empathy, which I look for, and great appointment.
Okay, we may begin the roll call.
Yes.
Eileen,
I'm sorry.
vote.
Sorry.
Sherry, Mike Sherry.
Yes.
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 Yes. Yes.
Yes.
Yes.
Okay, thank you. I recognize Counselor Ferreira for a motion to record advice and consent for the appointment of Brian S. Glenny to the position of Associate Justice of the Superior Court.
With pleasure, I make that motion, Governor.
Second.
There's a motion and a second.
Excellent.
We may begin the roll call.
No.
Yes.
No.
Yes. Yes.
Yes.
Yes.
Yes.
On that motion, I just want to say for the record, the vice of Honorable Cornelius J. Moriarty II, that's a Western Mass position. And he then moved down to the Cape with permission. But that's one of the ones they stole from us.
Okay.
Excuse me, can I ask, where did he live, by the way?
Holyoke,
That's why he was at a.
all of them. I think there was 9 Moriartys in that family.
Okay, we'll continue to talk about that, make sure that the needs of Western Mass
We're working on it.
are
Thank you.
served in the Superior Court.
Thank you. And district.
Okay, we have 2 nominations.
Oh.
Rachel Hirschbang has been nominated to the position of Associate Justice of the Appeals Court, and Counselor Devaney, that's within your district. You have a date and time for the hearing.
Where is she from?
Rachel Hirschbang.
It's my district?
Yes, it is.
Would that be the 4th of August at 1?
The 4th of August at 1 o'clock, okay? Aisha White has been nominated to the position of Circuit Justice of the District Court. That's within your jurisdiction, Counselor Kennedy.
I have to speak with them and I'll let everybody know this afternoon. After the hearing.
Okay, very good. We'll circle back to everyone with a date and a time. Counselor Devaney, you have something you'd like to bring
Yes,
to our
thank you.
attention?
Thank you for this opportunity. This is a letter, and I'm going to give it to you, Lieutenant Governor. And I have given this to the governor. Dear Governor Baker, I am requesting that you remove Sabine Herlihy from the position of Deputy Director of Human Services. She was not reappointed as judge on the Industrial Accident Board because of her unacceptable, rude, disrespectful behavior towards many injured workers. Sabine left in disgrace as judge of the Commonwealth of Massachusetts. Why is she being rewarded? Sabine Herlihy was withdrawn for reappointment to the Industrial Accident Board by a letter from Sabine Herlihy at your request on January 22, 2020. In 21 years as a governor's counsel, this was the first time I received calls to not reappoint a judge on the Industrial Accident Board. I received many complaints about her rudeness, disrespect, and outrageous comments. These complaints came well before the hearing. Attorney McKenna and Attorney Alaccio, most respected Boston lawyers, spoke at her hearing, asking the counselors to oppose her renomination. They spoke of many instances of her unacceptable behavior towards injured workers. I respect these gentlemen for putting their integrity and reputation on the line by speaking publicly against your nominee. I had already received a call about one of the cases they referred to. Attorney McKenna spoke about a very disabled man who was before Judge Herlihy. He was accompanied by his pregnant wife. Judge Herlihy replied to the injured worker, "Is that your wife?" He answered, "Yes." Judge Herlihy then responded, "If you can do that, you can work too." That one egregious action is enough to remove her But there were many more complaints that were waged against her. In August 24, 2020, at a public assembly, the councilors were waiting to hear a replacement for Herlihy. The lieutenant governor was asked why Sabine Herlihy is still getting a salary, still on the payroll of the Industrial Accident Board 8 months after being removed. The lieutenant governor said, and I quote, it's in writing, "I pledge I will look into the issue." Governor, you and Lieutenant Governor never made a further statement about this issue. I believe, representing the citizens of Massachusetts, I deserve an answer to your action of continuing Attorney Herlihy on the Industrial Accident Board payroll when she was removed from office with her letter and yours withdrawing her renomination in January 2020. Please explain how she continued to receive an additional salary from the Industrial Accident Board, $111,295 for at least 9 months after she was no longer a judge. In addition to that salary, please explain how she received a buyout of $8,250.70. What is that buyout? Please also explain the position of deputy. Is this a new created position? Was it posted? You had the authority, the opportunity to reappoint the most outstanding, qualified, respected people on boards and commissions, yet you replaced them. A few examples. Lee Gottenberg, after only 4 months on the parole board, who is the noted expert on parole matters and has advised the parole board for years. Frank Sharaffa, most respected, a mentor on the appellate tax board, 30 years serving, appointed by 5 governors. And you replaced him while he still had 1 day left in his term. He was working in the office when a staffer called him. Frank had brought billions, that's a B, billions of dollars over the years to the Commonwealth. About 25 years or so, he took on the phone company, the biggest case in one. Demanded phone company pay taxes on all the wires and poles throughout Massachusetts. He was replaced by someone who appeared before the appellate tax board once in 1991. Lucy Soto, most qualified, hardworking parole board member, appointed by 2 previous governors, outstanding. She also happens to be Puerto Rican and speaks Spanish fluently. What a value on the parole board. After 3 months, you removed the chairperson and appointed this new nominee who replaced Lucy as the chair. I have seen so many qualified good people not qualified for no cause. I have voted no with cause. It is unlawful to pay public money for no-show jobs. Not one of these people, not appointed, were kept on the payroll or given another position or a buyout. But Sabine Herlihy, who disgraced the honored position as a judge, disgraced the robe, yet she is rewarded for bad conduct, now with a new state position. No one with her egregious record should be allowed to even work in public service for the Commonwealth of Massachusetts. Past practice, and with due respect to you, Governor, I have never received a personal reply from you or the Lieutenant Governor on inquiries I have made. I am requesting a reply now. Governor, I take no joy in this request, but I took an oath of office and I honor that pledge. With other requests, your staff has made it clear that it's not my position to question. I have been given Mass General laws when they don't apply. I have just cause to make this request. Please respond as soon as possible. Respectfully submitted, Marilyn M. Petito Devaney. Thank you for the opportunity. Would you give this to the Lieutenant Governor?
We have that. We received your letter today, and we're in the process of responding to you.
Okay.
All right. I want to say what pleasure it is to be back in this room with all of you. It has been a very challenging year
Get the rest of them back in.
for everyone. So I'm very happy we're back here. Thank you for all of your hard work over the course of this past year. You did not miss a beat. And the band's back together here in the Governor's Council chamber, and I'm happy to be with all of you. But
And we'll resume the hearing at 1:30.
we'll resume the hearing at 1:30, so you have an hour break. Thank you very much.
I just
And-
want to say thank you to Sonia and Valerie and Adam for making this all happen. Well, we were out because frankly, they're the people behind the scenes that make the clock tick. So thank you, Stephanie.
And also, I would say to the counselors, do your own letters now. They were going beyond their duties to do the letters during the pandemic. Now it's your turn to do your job.
Okay, that concludes our business today. Thank you, everyone.
Hey,
Nice seeing you.
So
You look
you
great.
want to change that?